Define Malaysia Federal Constitution. The Federal Constitution of Malaysia, considered as the supreme law in Malaysia, which came into force in 1957. It is formed after the Constitution of the Federation of Malaya, which is also the Federal Constitution of Malaysia today. It is drafted by a Red Commission that headed by Lord William in order to formulate a constitution. Eventually, the threat of communist uprising that are spread through Malaya had affected the formulation of the Constitution of Federation of Malaya, and yet the growth of Malay nationalism had contributed many alternative ideas on the shape of Malayan nation. Therefore, Red Commission had sought the viewpoints from several political parties, non-political organizations, and individuals in order to find an appropriate government structure that only suits for our country. In the report published by Red Commission in February 1957, they suggested that the Constitution should protect individuals' rights and ensure a democratic way of living.
Okay, Article 5, Liberty of the Person. Okay, life is a personal liberty, can only be deprived in law. Fundamental liberties are the rights and the freedom for all human. As for the Article 5, which explains about liberty of the person, okay, to make it clear under this article, an individual has the right to know why he was arrested and to be legally represented by a lawyer of his choosing. Okay, no person may be deprived of life or personal liberty except in accordance with the law. Okay, next is a person who is unlawfully detained may be released by the High Court. Okay, last but not least, an individual may not be detained for more than 24 hours without the permission of a magistrate. Okay, for example, for this Article 5, okay, 3 transgender women had been repeatedly arrested, detained, and prosecuted pursuant to Section 66. Okay, Section 66 makes it an offence for a Muslim man to wear a woman attire or pose as a woman in public. Okay, the appellants applied for judicial review for Section 66 of the Sharia Criminal Enactment 1992 Negeri Sembilan on the grounds that it was unconstitutional. Okay, this is because the appellants described that they have gender identity disorder or GID. Okay, from a young age, each of the appellants had been expressing themselves as a woman. Okay, under this Article 5/1, the court found merit in the appellant's arguments that stating that as long as Section 66 is in force, the appellants will continue to live in uncertainty, misery, and indignity. Okay, citing previous case law, the court noted that Article 5/1 encompasses the right to live with dignity. Okay, Section 66 was therefore inconsistent with Article 5/1 because it deprived the appellants of their rights to live with dignity.
Article 8, Equality. In Article 8, it mentioned about the right and liberty in Malaysia. To be specific, it mentioned about the gender equality. This is to help non-discrimination against female based on cultural definition of her social role, non-discrimination against female based on biological sex difference, non-discrimination against males based on biological sex difference, and cultural associated interpretation of behavior based on sex difference. Gender equality is defined in global constitutional law as both sameness and difference. Concepts that are included in the Day 4 have standards that prioritize equality of opportunity and outcomes. Local jurisprudence has yet to address this issue.
Article 11, Freedom of Religion. This article provides that first, every person has the right to profess and practice his religion and subject to Clause 4 to propagate it. Second, no person shall be compelled to pay any tax, the proceeds of which are specially allocated in whole or in part for the purpose of a religion other than his own. And the third, every religious group has the right to manage its own religious affairs, to establish and maintain institutions for religious or charitable purpose, and to acquire, own property, hold and administer it in accordance with law. Fourth, state law, and in respect of the federal territories of Kuala Lumpur and Labuan, federal law may control or restrict the propagation of any religious doctrine or belief among persons professing the religion of Islam. And the fifth one is this article does not authorize any act contrary to any general law relating to public order, public health, or morality.
Hierarchy of the court and its jurisdiction. Okay, despite Malaysia's federal constitution, the judiciary is largely centralized and strongly influenced by English common law as well as Islamic jurisprudence. Malaysia has followed the English common law system, and its judicial system is structured according to the English judicial hierarchy. With the federal court as the highest court, the Court of Appeal, two high courts, which is Malaya and Sabah and Sarawak, session courts, and magistrate courts are all below the federal court. There are generally two types of trials, which are criminal and civil. Okay, the jurisdiction of the courts in civil or criminal matters are contained in the subordinate courts Act 1948 and the Courts of Judicature Act 1964. Okay, Article 121 of the Constitution provides for two high courts of coordinate jurisdiction, the High Court in Malaya and the High Court in Sabah and Sarawak.
The Superior Court. Basically, the Superior Court is Malaysia's third highest court according to the court hierarchy after the Federal Court and the Court of Appeal. According to Article 121 of Constitution, there are two high jurisdictions to coordinate the High Court of Malaya and the High Court of Sabah and Sarawak. Federal Court. Basically, the Federal Court is the Malaysian highest court where the Federal Court grant leave. It may sound appeal from civil decision of the Court of Appeal. The Court of Appeal also hear criminal appeal from the Court of Appeal, but it is only matter that heard by High Court in its original jurisdiction. For example, where the case may have not been appealed from the subordinate appeal, except for judgment or order made by consent, the Court of Appeal hears all civil appeals against decision of the High Courts. In cases where the claim is less than Rm 2,500, the judgment or order only relates to cost, and the appeal is against the decision of a judge in chambers on and interpret the summons based on claim base. The Court of Appeal must first grant leave. Malaysian two high court have general supervisory and reversionary jurisdiction over all subordinate courts, as well as the authority to hear people from subordinate courts in civil and criminal matters, other than action involving motor vehicle accident, landlord and tenants conflict or distress. The high courts have unlimited civil jurisdiction and generally hear action where the claim exceeds Rm 1 million. The high courts hear all cases involving divorce, bankruptcy and custody. Involving of Islamic law, the High Court has unlimited jurisdiction in all criminal cases. In death penalty cases, the High Courts have original jurisdiction. Cases are heard in the High Court by a single judge or by a juridical commissioner.
I will talk about the hierarchy of the court and its jurisdiction of the subordinate courts. In Malaysian legal system hierarchy, the subordinate courts comprises the session courts, the magistrate courts and other courts which consist of the Penghulu courts in western part of Malaysia and the court of the children. The magistrate courts as well as the session courts in Malaysia have jurisdiction in both civil and criminal matters. The sessions court. These are those courts in Malaysia which are somewhat similar to the former quarter sessions in England. The session court is divided into civil and criminal jurisdiction matters. First is civil jurisdiction. A session court may hear any civil matter involving motor vehicle accidents, disputes between landlord and tenant, and distress actions. The sessions court may also hear other matters where the amount in dispute does not exceed 1 million. The second one is the criminal jurisdiction. A session court has jurisdiction to try all criminal offences except those are punishable by death. The second one is the magistrates court. This court deal with the vast majority of cases, both civil and criminal, and sit in almost all major towns in Malaysia. These courts are divided into first class and second class magistrates. The first class magistrate, under civil jurisdiction, it may hear a civil case when the amount in dispute does not exceed 100,000, and under criminal jurisdiction, it may hear criminal matters of the following nature: in which where the offence is punishable by a fine only. This will cover the majority of the traffic offences, or where the offence provides for a term of imprisonment not exceeding 10 years. However, a first-class magistrate may not impose a term of imprisonment exceeding 5 years, a fine exceeding 10,000, whipping exceeding 12 strokes, or any sentence combining any of the sentences above. The third one is the penghulu court. The penghulu courts hear civil issues in which the claim is below 50 ringgit and where the offenders are of Asian race that speaks and understands the Malay language. In penghulu's courts, criminal jurisdiction, it is limited to offences of a minor nature charge against a person of Asian race which is specially enumerated in his warrant, which can be punished with a fine not exceeding 25 ringgit. Last but not least is the Court of Children, which is previously known as a juvenile court. This court is for the issues related to the minors who are below the age of 18 years old that are suspected of having committed criminal offences. It deals with children who are beyond parental control or who need care and protection.
Position of Sharia court. Okay, unlike the High Court, which is established by the Federal Constitution, the Sharia court has been equated to the Session Court and the Magistrate Court, which in the Federal Constitution are called as inferior courts. Okay, the Sharia courts are mere state courts and do not enjoy the same powers or the same status as the High Court. It follows that the High Court has supervisor powers over the Sharia Court, just as it has supervisor powers over other inferior tribunals. Okay, quite clearly, the Sharia Court cannot be considered any greater than the inferior courts. As for the example, in exercising its criminal jurisdiction, the magistrate court can impose a sentence of an imprisonment up to 5 years and a maximum fine of 10,000 and whipping up to 12 strokes. Meanwhile, the Sharia court, in its criminal jurisdiction, is Court was not precluded from hearing and determining the issue. Okay, it is also inaccurate to hold that the Sharia Court has exclusive jurisdiction on all matters related to Islamic law. It follows that the High Court has supervisory powers over the Sharia Court.
Legal profession is a legal paid occupation, especially one that who want to prolong training and a formal qualification. Usually, there is a requirement for someone choosing a career in law to first obtain a law degree or some other form of legal education. The Malaysian Bar is an organization that involved in the legal profession. It is established under the Advocates and Solicitors Ordinance 1947, was subsequently repealed by the Legal Profession Act 1976. Its aim is to uphold the rule of law and protect the interests of the legal profession as well as the public. The legal profession in Malaysia is actually fusing approximately 16,000 membership. Whoever owns a valid practicing certificate is officially one of the Malaysia Bar's member. Another organization that related to the legal profession is the Legal Profession Qualifying Board Malaysia, which is we call it as the board, was established under Part 2 of the Legal Profession Act 1976.
So essentially, one of the functions of the board is to decide on the qualification which may entitle a person to become a qualified person within the meaning of Section 3 of the Act for purposes of admission as an advocate and solicitor in Malaysia. Under this organization, there are some institutions which has been recognized for entry into the legal profession in Malaysia, and one of the institutions is our own university, which is University Utara Malaysia, holding the certificate of AU0013 honors. Moreover, the Association of Women Lawyers, also known as AWL, also involved in legal profession in Malaysia. It was established in 1983 by their founding member who willing to sacrifice and give full commitment. Their tireless advocacy and lobbying efforts culminated in the passing of Domestic Violence Act 1994. It is an organization to eliminate discrimination and ensure full and equal participation of women lawyers and law graduates in the legal and related fields. It also aims to ensure the attainment and full enjoyment of all rights for women from all walks of life based on principle of substantive equality.